Good morning. Mr. Tynan? Good morning.
Good morning, Your Honor.
Mr. Tynan, let me just explain. You have 10 minutes, and
I
the
won't
clerk
be that
will...
long, Your Honor.
And you know about the lights. When the yellow light starts to flash, you have 1 minute left, and when the red light starts to flash, you stop. Good morning. You may proceed.
Thank you. Your Honor, as you know, in healthcare and in Schuman, Amendment 48 was attacked for its legislative nullity. To cut to the chase, the legislative right, as announced in 48, to veto the people's rights to vote. I counter that with the authority of Article 7, which contains within it exclusive and specific language as to who will reform, alter, or indeed totally change the government. The court and the legislature are branches of the government. This analysis manifests itself in two specific jurisdictions. One is contained within the Constitution, Part the First, the Declaration of Rights. The second is contained within the Constitution, the second, the frame. There is such clarity to Mr. Adams' words that I find it, from my position as being autistic and working in logic, impossible to find that these two competing constitutional codicils could exist. The court said, in the opinion of the justices in 1857, that the Massachusetts Constitution empowers the general court to enact only those laws, statutes, and orders, wholesome and reasonable, that are not repugnant or contrary to the people's Constitution, and that the legislature more or less thinks that's in a good welfare. This law was not achievable. Article 7 cannot be contested, it may not be voided, and the right within it is inalienable, meaning that it is non-transferable. The people could not give, nor could the legislature in any way extract, wholly or in part, a veto over the people's right to control their government. That just cannot be done. It's as simple and it's as clear as that. And I really don't know what else to tell any of you. I'm certainly not here because I want to be. It's very difficult for me to even be here. And I don't want to be here. But these things cannot coexist. I've come to this court after a long struggle when I could have went to the United States court. This is Massachusetts. I was born, I was raised here. This is an anomaly. We can fix it ourselves. We don't need to have a bunch of people in some place called Washington decide something for us. This is wrong. If you look at them, they're there. It is just there. You couldn't get there, as we say in Maine. You can't get there from here. There's no way to do it. I've asked repeatedly the Commonwealth for an answer. Branch after branch after branch. Now I've come to this court. Test the tensions. If Article 48 was lawful in 1918, then it would withstand a test of tensions today for constitutionality. I recognize the dangers involved. I understand what can happen and what cannot happen. But that was not my function. My function was to look at the amendment, at the legislators, vote, not to vote, and find a way of collateral attack. I have attacked it in 7, the doctrine of issue preclusion or collateral estoppel prevents the state from ever enacting a law that would put it above its people. Amendment 48, as it says in the brief, reduced the people to subjects and elevated the courts, be it this court or the general court, to rulers. Now, I'm unhappy with it too, but unfortunately, I can't find any other logical resolution in my mind, mathematically or legally. And that's basically it. I can't help you with it. You have to wrestle with the question yourself and kind of figure out what it is. But it deserves a test of tensions. The people of Massachusetts have signed in astounding numbers, 500 voters per district. Pursuant to Article 19, now repealed, the legislatures are supposed to return to their constituents, to caucus with them, and to take instruction from their constituents as to any bill or paper that is laid before the legislature. There is no independent right in Massachusetts to vote your conscience. That was created in part by the annulment of, or the enactment of, Amendment 48. And the key to it, Your Honor, is that in 48, they say this section shall not be open to a ballot initiative. That's essentially what John Adams said when he said, therefore, the people alone have an incontestable, inalienable, indefeasible, or non-voidable right to institute government, to reform, to alter, or totally change the same whenever their happiness, safety, prosperity requires it. That's the end of the game. That's all. I don't have anything else that I can help you with. If I can answer a question for you, I'll be happy to, but basically that's all I have to say.
Thank you, Mr. Tynan. I don't believe there are any questions. Thank you. Mr. Sachs? Mr. Sachs?
Unless the court has questions, Your Honor, the defendants will submit on their brief.
I think that the brief is, at least from my point of view, adequate. Thank you, Mr. Sachs. Mr. Tynan, as you know, we will take this under advisement, and a judgment will issue sometime later, within 130 days. Thank you.